Morning, teacher. This is our presentation for contract and corporate law case studies that we conducted as per the assignment. We're group S315 and my name is Jerome Sell. I'll start with the first two questions, cases, and then my colleagues, students will each take their turn in answering the case studies. So the first question is about Ming opening a hairline shop and placing an advertisement in one of the local papers where she provides the conditions for potential customers that bring the advertisement to the shop to do a haircut for $10 instead of the usual $60. 40 customers show up the day the shop opens with the advertisement, demanding a haircut for $10. Ming is a bit surprised negatively for the amount of people that actually show up. So he puts on a sign saying that the offer is no longer valid. The first question is are those 40 customers that show up with the advertisement, is Ming obliged to fulfill the contract? The question is there a contract and does she need to fulfill it? And actually there is a contract and he will have to do the haircut for $10. The reason is there's 5 essential elements of the contract are present according to Lincoln. These are a legal intention to create a contract, which is the advertisement. It's not solely an invitation to treat, because the conditions in the advertisements are very clear, are non-negotiable. There doesn't need to be any negotiations and can be accepted as they are. So there's no doubt about there being an offer. Plus then the potential clients show up with the advertisement, as is one of the conditions, and accepts. So they accept the offer of Ming and take into consideration bringing the advertisement. So Ming will have to fulfill the contract and do the haircuts in this case. There's no question about legal capacity because no underage, etc. That was question 1 for the 40 customers that bring the advertisement. On the other hand, those customers that didn't bring the advertisement, so those other 10, question B, actually Ming doesn't need to do the haircut for $10 in this case, because the condition was to bring the advertisement and that wasn't brought. So they didn't act as per the terms of the contract, so there's no contract in that case, and Ming is not obliged to do a haircut for $10. Thank you. Next up is the following question.
Good morning, my name is Asha Nadwal and my student ID is GG2015, and today I'm explaining the question number 3 and 4 of my business and corporation law subject. So the first issue is Ming can claim that there's no legal obligation for providing the protect hair price of is very less. So according to the contract law, a contract come into the existence of the rule which is acceptance of the offer, and after that this is the contract, both parties have legal obligation. So the contract mentioned that Millings will have law provide, which is very $10 and to those who come with the advertisement. So the conclusion of this, that Milling cannot claim that because there is no legal obligation in this issue. The other issue is that there is an obligation of Milling after withdraw a promotion. So this offer can be terminated in a number of ways. So these are conference by acceptance, rejection, and over time slap, regulation, performance, and so on. So in that case, with the promotion withdrawn, the offer has been terminated and thus is not a customer. Therefore, there is no contract to be found in that. So the conclusion is that is held that with the withdrawal of the promotion, the offer is terminated and have no any legal obligation. I hope you like my issues. Thank you so much.
My name is Dharmendra Yadav. I'm going to give the group presentation. We have two topics in our case study. And first one is contract law, and second is corporate law. In corporate law, I have two questions. First is, are Lucy, Samus, and cooperating business partnership, that is partnership firm or not? Uh, According to our rules, a partnership exists when there is a contract between two peoples or more than two peoples, associations, and a common business purpose. The business have their certain goals, and there are two types of partners. One is unlimited liabilities, and one is limited liabilities. It is that is categorized on the basis of liabilities. And our application, there are three required elements for a partnership to exist are found in this case study. That is contract between people, association, and common business objective or business purpose, that is profit generation. And conclusion, hence these three persons are acting in a business, that is partnership. And another question is, if there is a partnership, can Co and Lucy be held liable for purchasing the read on more? The rules is Partnership Act of 1963 mentioned that the partnership are held liable for the actions of their partnership business as per section 16. Application, they have legal obligation for each other's activities or action. Conclusion, thus Lucy and Co have to purchase the read on more. And furthermore, I like to invite my friend Asim to cover more part about corporate law. Thank you.
Thank you, Dharmendra. It's me, Asim. My student ID EMB21099. Here I am dealing with two issues. First one is, can Ming claim for no legal obligation for providing cheap haircut as the price is very insufficient? For this, a contract is formed with the acceptance of the offer and has legal obligation for each of the involved parties. The contract entails that Ming will provide cheap haircut of $10 to those who come with the advertisement. As a conclusion, Ming cannot claim for no legal obligations. Second is, after withdrawal of the promotion, can there be no legal obligation for me? For this, the rule is offer can be terminated by time lapse, revocation, death and disability of parties, performance in the contract is held as illegal. As an application, withdrawal of promotion terminates the offer. As a conclusion, Ming will not have any legal obligation. This is end of my part. For further, I would like to call Deependra. Thank you.
Thank you everyone. My name is Dilwad Papa and my student ID is GCB2079. Today I'm going to start my presentation for a second part of the question about company law. Under my presentation for question number 5 about the issue of the partnership after the death of one partner. According to Houghton KA 1982, partnership will end after the death of the one partner. So that means the partnership will not exist after the death of the one partner. And the second part of my presentation, it is in question number 6 about the partnership property and the losses distribution. So as per the question, about property has been contributed to the members, like by the members who contribute the properties. So in my questions, so like Lukic contributes truck, co-contribute the computer, and Simmons contribute the lawn mower. So which are identified in question. So this property have been distributed after their covering the debts of the company. So thank you. This is my overall presentation about the conclusion part of my assignment. Thank you everyone.